Hi friends from around the world. This is level 3. So level 1 was, let me recall, level 1 was for the general public, level 2 was for IP lawyers from around the world, IP students and some business owners interested in IP and the importance of IP, if they understand the importance of IP of their business, though they would be interested in level 2. Now, level 3 is more substantiated, is more legal content, so it is targeting IP lawyers, either from Europe or from around the world. IP lawyers who have an understanding of the system of the intellectual property in Europe. So it is about the central system. It is not about the national system, which also exists, right? The central system, which give a unique title for the whole European Union, like trademarks and designs. So it is also for lawyers, so from Europe and from outside Europe, those at least who have followed the trademark course or the design and the design course, which is available on this channel, and have some fundamental knowledge about how the system in general works. So these are the target public IP students. Well, they are also welcome if they have followed the different courses on level 2 in order to get to level 3. But this is more about the practicing part. So those who are interested to know the tendency of the practice of the courts or the practice of the EUIPO, this is the place to be. But it is highly technical, because I will not repeat what I have told in level 2. It is not worthwhile. So once you get through level 2, you are here on the right place. Now, EUIPO is one of the top 5 intellectual property offices from around the world, beside US, China, Japan, South Korea, and Europe. And it receives, I will give you some statistical numbers, it receives a lot of filings for trademark filings. We receive, well, here you have the statistics online. We have 200,000 more or less in 2021, 200,000 filings, of which we have opposition, some 20,000. Then appeal decisions, we have between 6,000 and 8,000 or so. And court judgments, we have about 300-400 a year. So we are rather in the cruising speed. That's what we still are on growth side with regard to the filing, but it is rather, I would say, we are on the cruising speed with regard to all of the filings. You know that the trademarks are already applied or in place. The system is in place since 1996 for designs. It is 2007, so it is some 30 years already for trademarks where we are. Well, not 30, but 25. Okay, so this is about the numbers. You can make up a bit the possibility or the possibility of being sued in opposition or in court. What is the probability? What we have is more or less that 80% with regard to the court judgments, right, in Luxembourg. 80% of the cases, 80% of the cases which come before the court in Luxembourg are confirmed. So you have a 1 in 5 chance that you will succeed in Luxembourg. It is also quite expensive to go to Luxembourg. The lawyer fees are quite expensive, whereas the court fees are non-existent. Okay. On the also here on the screen, what we have is mainly the tendency is quite astonishing, but well, we are on a cruising speed, but we have 50% of fast track and 50% of normal applications, normal filings. And we have, well, the whole majority, 99% or so, electronic filing. So this is a wholly electronic system. They have an EUIPO. Everything is electronic workflow now. So that's to say the state of art where they are working there. Now that is it for the trademarks. On the design side, what we have is some 100,000 or so designs a year as filings. Some designs, half of them are more than one filing, because you know they have a reduction there for the filing fees if you file more than one design for EUIPO. So out of these 100,000, we have some 300, 400 cases of invalidity requests. You know that the design cases, they pass directly to registry, not unlike the trademarks, which have an opposition before registering. So in the design cases, it is proceed to registry immediately, and even within a very short time frame. And then you got the possibility of invalidity. Well, in the trademarks, you have also the cancellation proceedings, which is after registration, and it is still there, right? So this is about some statistics for seeing how is EUIPO can be viewed from the outside, from the practicing lawyers, and how others are doing, and what is the importance of the one and the other in the work of EUIPO. Now I'm going as a previous work to this series of videos, I'm going through the hundreds of decisions, or hundreds of or some of the judgments, in order to filter out what can be seen as a landmark decision, as something which adds value to the practice of the lawyer. So you want to an efficient way to get to know what are tendencies, and you do not want to put all the work into what is necessary in order to get that knowledge out of it. That would cost you too much. You want to have it reduced to a concentrated level of information, and that is what you get here. It is not necessary that you get through. If it is condensed in one place, you will get it much cheaper and much more efficient if somebody reduces for you all that work. And that is what this list of videos is about. You will have it according to years, so I will make it yearly screening, and out of the yearly screening I would filter out those which have more interest for the practice of the lawyers, and then I would filter also according to what is it about. So it would be about absolute grounds in trademarks and relative grounds in trademarks, depending on what I see on the landmark, or what is worthwhile to be qualified as a landmark decision or landmark judgment. I would then also put some enforcement decisions perhaps, or on copyright, or on everything which could be interesting for the practice with regard to the existence of annual decisions of decisions of the court, which could bring added value, I want to put it here on the channel. So that is it what I want to tell you for this channel. These are the intentions. We will see how this works out. Thank you for tuning in for today.